Hi, I'm making this video as an update to the video that I published on November 4th, 2014. It deals with the heinous intrusion into my emails by the Somerset County Prosecutor's Office, basically the state of New Jersey, in which during my trial for alleged theft, the state of New Jersey breached the attorney-client privilege between myself and my attorney. Fact 1. During this alleged theft trial of Linda Williams, which took place between August 18th and August 27th of 2014, all of the witnesses were under a sequestration order, which basically means, and please believe me, I'm no attorney, that the witnesses were not allowed to talk to, visit, communicate in any way with other witnesses or the supposed victim, Linda Williams. Fact 2. On August 24th, 2014, I was arrested and my home searched for an alleged violation of a no-contact order. The arrest warrant, which was served to me at 9:30 at night, had the words that were used were observed and investigated by Mr. Ordell Taylor from the Franklin Township Police, who most importantly was the prosecution's main witness, who at the time was still in the process of being cross-examined by my attorney. Fact 3. The arrest warrant for this alleged no-contact order was signed by Judge Marino, the judge overseeing the Williams bogus case. But the search warrant for my home was signed by a different judge by the name of Miller, and I am told that this is highly irregular. Fact 4. Between September 16th and September 19th of 2014, my husband obtained information through the Microsoft Outlook website. He obtained and printed out all email logins recorded during the period August 25th, 2014 through August 28th, 2014. What we found was that my emails were accessed from my phone, which they took in that bogus search warrant of my home. And as of August 24th, it was in my phone, along with 3 iPads, audio tapes, cameras, jump drives, were all in the possession of the Somerset County Prosecutor's Office, or should I say the state of New Jersey. We discovered that my emails had been breached by using my iPhone over 800 times. More importantly, my emails contained numerous, over 3,800 emails back and forth between myself and my attorney, which contained trial information, trial strategy, which we discussed. One could only view this as a deliberate and egregious violation of attorney-client privilege, which is no surprise for the state of New Jersey. On September 19th, 2014, we did put in a formal complaint with the Federal Bureau of Investigations against the Somerset County Prosecutor's Office, the state of New Jersey, the New Jersey Attorney General's Office, as well as the Franklin Township Police Department and the Deputy Prosecutor, Nicole McGrath, and Ordell Taylor, the detective of Franklin Township. Fact 5. On October 8th, 2014, my attorney filed 2 motions. The first motion was for a complete dismissal of the no contact charges. The second motion was for a complete dismissal of the Williams case due to the state of New Jersey intruding into my emails and by doing so breaching the attorney-client privilege. The information that was sent to both the court and the prosecutor also included the Microsoft login information, which my husband printed out between September 16th and September 19th of 2014. Fact 6. On October 9th, 2014, my husband received 2 summons for harassment, both signed by Mr. Ordell Taylor of the Franklin Township Police Department. The charges were later dismissed after the Franklin Township Court dragged my husband into court with his attorney a number of times in the subsequent 12 months that were to follow. My husband won those cases. Fact 7. The date for the email motion was set for December 16, 2014. On December 15, 2014, my attorney called the judge's chambers to make sure of the time for the motion to be heard. And he was told that the motion was canceled and will be heard on January 20th, 2015. Fact 8. On January 12th, 2015, my attorney finally received Ms. McGrath's, who is the Somerset County Prosecutor's Deputy Prosecutor, response to the motion. Bear in mind that New Jersey law does state that a response does need to be submitted for a motion to the court and the defense within 10 days after the filing of the motion. On January 12, 2015, it was 96 days. Fact 9. On January 20th, 2015, McGrath stated that she did not need my phones, iPads, jump drives, audio tapes, all the things that I had mentioned previously that they stole from my home, because Linda Williams had surveillance. McGrath also did not believe the Microsoft login documentation. As an added note, we still have not had our property returned that was confiscated or stolen, even though the charges that spawned this illegal search warrant was dismissed. But I'll get to that. McGrath believed that my husband lied. Judge Marino asked McGrath if she obtained a CDW. She said no. A CDW, from what I could find out, is something that they need to have prior to looking into any type of electronic equipment. Judge Marino also said she would be happy to sign court orders to obtain information from Sprint PCS, which was my phone company. Fact 10. On January 27, 2015, my attorney sent to the court orders for Judge Marino's signature. Fact 11. On February 27, 2015, the motion for the no contact was to be heard. I and my attorney went to the court, but was told that the motion was again postponed until April 14, 2015. Fact 12. My attorney had called the judge's chambers multiple times during February and March to find out when he will be receiving the signed court orders so we could obtain the Sprint PCS information. He was never given an answer, and in March my attorney sent a subpoena to Sprint PCS for the information that we wanted. Fact 13. On April 13, 2015, the no contact motion was postponed until April 15, 2015. Fact 14. April 15th, the motion was dismissed of the bogus no contact charges, which was finally heard, and we won the motion. I do not know what the legal terminology would be, but that's what happened. We won. Prior to leaving, Judge Marino did ask my attorney if he had received the signed court orders. He stated no. Before he was able to say anything else, McGrath stated that she didn't like the wording of the court orders. So instead of calling my attorney, sending an email, a letter, she simply just let the court orders sit on her desk for 3 months. Fact 15. Shortly after April 15, 2015, we received the information from Sprint PCS, which that the amount of data received from the Microsoft mail server to my phone, and let me try to explain this because I am in no way a computer expert or anything. Basically, if you ask your phone to get a specific email, it sends a message to this mail server and basically saying, please give me this email. The email then is sent to your phone and it's open. What was found was that approximately 32 megabytes, which approximately equals 8,500 full printed pages from top to bottom and side to side at a font size of 12. So you can imagine the amount of data that they stole. Fact 16. Immediately, once we received the information from Sprint, we did hire a computer expert. And on April 24th, 2015, our expert's report was sent to both the court and the deputy prosecutor, McGrath. Fact 17. May 8th. There was a status hearing. A woman named Kerry, who is the person who does Judge Marino's scheduling, had my attorney and I wait to be seen by the judge until approximately 4 p.m., and that was from 9 a.m. McGrath was not there, but she sent another deputy prosecutor named Anne-Marie Muller, who was told by McGrath to ask Judge Marino for 5 to 6 weeks to see if they wanted to get an expert. Fact 18. On May 8th, 2015, at 4:46 p.m., my attorney received a call on his cell phone by McGrath, which stated, and I will read you the transcript. Paul, this is Nicole McGrath. I just talked to my associate, Anne-Marie Muller. She said she handled my case for me in regards to Linda Lupo. And she had put on the record the fact that you know we are looking into hiring an expert, and I guess you gave her a hard time. That you had already gotten your expert within a week, which I'm very surprised that you would say anything given the fact that this has been going on for months, and because of the motion that you have filed and the amount of time it took for you to retain the records. Well, that's a bunch of bunk, because she was the one who continually tried to prolong this motion. Nonetheless, I think that we are ready to expedite this. If I can get your client's consent to look through her phone and her iPad to determine, we can do a phone dump on it, and we will be able to determine what exact dates, if any, emails were opened and what exactly happened with the phone, because my computer people, now please recall that 48 minutes prior, she sent Anne-Marie Mullen in there saying that they wanted to get 5 to 6 weeks to see if they wanted a expert. Yet now she's talking about her computer people. Computer people that I've talked to said that your expert's report says that emails were accessed, and all that means is that the iPad or the phone was communicating with the local cell tower. The emails were being viewed, and we will be able to determine by doing a phone dump and an iPad dump whether emails were actually opened or not. So I just need your client's consent to be able to do this. Please give me a call. And then she hung up the phone. Well, that's a bunch of bunk also. After speaking that night with our expert and many experts, a phone dump would not yield her that information. Fact 19. On May 11, 2015, my attorney wrote both an email and a letter, which was sent to McGrath and Judge Marino, about that absolutely inappropriate message McGrath left on my attorney's phone. Fact 20. On May 13, 2015, my computer expert wrote a supplemental report explaining to the court, Judge Marino, and to McGrath how a cell phone dump would not give them the information that she stated in her rambling voice message to my attorney. Fact 21. On May 27th, McGrath sends a letter to both my attorney and Judge Marino asking for this motion to be dismissed. Amazing. Fact 22. On May 29, 2015, there was another status conference. There was another status conference. Again, Kerry, the girl who does Judge Marino's schedule, had my attorney and I wait till we were pretty much the very last people seen by the judge. On May 20, Fact 23, on May 29, 2015, my expert received 2 voice messages from McGrath's expert, who was Omar Belgrave. And on May 30th, 2015 and May 31st, 2015, McGrath's expert actually went to my expert's home with the obvious intention to intimidate him and harass him. You'll be able to see this video surveillance from my expert's home at the end of my video here. Below is just one of the transcripts I'm going to read to you from Mr. Omar Belgrave. Hi, hello, this message is for, and I'm going to leave my expert's name out, or anyone in his corporation. My name is Omar Belgrave. I'm a sergeant at the Somerset County Prosecutor's Office in Somerset County. I'm calling in reference, I want to speak to someone about a report that I have here, written by someone from, well, supposedly written by someone from your company. It's a report about information and subscriber information from a Sprint phone. If I could get someone to return this call, I would really appreciate it. My number is, and he gives his number. You could contact me on my work cell phone. And again, my name is Omar Belgrave. I am a sergeant for the Somerset County Prosecutor's Office in the Computer Crime Unit. My suggestion, Mr. Belgrave, go back to school. Trust me, you need it. He also states that actually myself and another detective responded, and he used the word responded, which is a out and out lie, to my expert's home. He gives the address. I do believe that your company or home, which is a townhouse, has surveillance stuff outside, so you may see us on your surveillance camera. That would be myself and another co-worker of mine. So if you could return my call, I would appreciate it. Thank you. Well, and you will be able to view that video yourself, but you could see that his friend who went with him had his hand on his gun at one point. If this is an intimidation, I have no idea what it could be. Fact 24. on June 2nd, 2015, my attorney wrote a letter to both the court, Judge Marino, and McGrath about the attempted intimidation and harassment of my expert. Fact 25. On June 19, 2015, my attorney received Belgrave's report, which was ridiculous. Again, Mr. Belgrave, if you are seeing this, go back to school, because trust me, you need it. Fact 26. July 1st, 2015. The motion was to be heard, and again, less than 24 hours, again rescheduled for August 13th, 2015. Fact 27. On August 12th, 2015, at 5:47 p.m., my attorney received a voice message from McGrath, and this was to his office phone, not his cell phone, which she did back on May 8th, stating that tomorrow, August 13th, she will have a rebuttal expert in court. Fact 28, August 13th, 2015. The motion obviously was not heard, again, but Judge Marino did set out a specific timetable, and she also stated there will be no further delays, and the motion was rescheduled for September 15th, 2015. Judge Marino specifically used the term preemptive with regards to the date. And in speaking with my attorney, that means that everyone has to clear their schedules. There is no reason why on September 15th, 2015, that motion will not be heard. Well, think again. Fact 29. On September 14th, 2015, my attorney received a call from the judge's chambers, this Kerry person, that the motion is again adjourned. It took well into the end of the day on the 14th, and several phone calls by my attorney's office that the motion will be heard then on September 17th, 2015. Fact 30. On September 16th, 2015, my attorney received an email stating that the motion will be adjourned again until December 1st, 2015. This has been a constant adjournment. Over 9 times the prosecution, Ms. McGrath, had this adjourned. This type of behavior is not only corrupt, but is a far cry from the supposed changes that they were to have back in 1996, when Somerset County's prosecutor's office had a huge corruption problem. Well, guess what? From 1996, they have not changed. Thank you so much for listening to this. I appreciate all your time. I will update you, and after this is over, you will be able to see the video from my expert's surveillance. Thank you. Bye.